Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So, we received an interesting inquiry here on our YouTube channel. This has to do with somebody who was accused of giving drugs to a minor. Let's see here. My 17-year-old, a minor, son was accused of having locked a 16-year-old classmate, forcing drugs on her. Oh God. Well, first of all, locking somebody in a room is a big no-no. That's a felony under Penal Code Section 236, false imprisonment, that carries up to 3 years. Now, because your son is a minor, he wouldn't be looking at 3 years state prison, but he could be looking at a potential of 3 years in a juvenile detention facility. Now, regarding giving drugs to a minor, well, he could theoretically charge with distribution of controlled substance, distributing controlled substance. That would also be a felony that carries carries up to 4 years under Health and Safety Code 11351. Distributing drugs to minor, that's a no-no. Now, also, contributing, you could also be charged with the contribution to the delinquency of a minor. That's a misdemeanor under Penal Code Section 272. That carries up to 1 year. Now, like I said, because your son is a juvenile, he's lucky he's not 18. If it was 18, this would be a lot worse. But because he's a juvenile, this is a case that's going to go to juvenile court. And, you know, you're going to have to go to court if you want him to be released because there's no bail system. In the juvenile system, you have to show that you're going to be responsible for your child, and if the judge is satisfied that you'd be responsible, the judge would release him to you with an electronic home monitor. Barring that, your son would have to be in custody until this case resolves. Now, obviously, your attorney has to go in there just like in any other criminal case, and he has to order copies of the police report and any other physical evidence that they might have. The judge would give a new court date to come back and start discussing the matter with the DA's office. At a certain point, a decision has to be made if this case has to be taken to a trial or if it needs to be resolved with the DA. Now, keep in mind that in juvenile court, there is no trial by jury. In juvenile court, there is no trial by jury. The judge will be the undisputed decider of your son's fate, and judges tend to convict people far more often than juries because it's much harder to sway a judge emotionally. So keep that in mind. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court here in the San Francisco Bay Area, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who was accused of hate crime, hitting somebody on purpose with their car. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorneys, Alexander Cross attorney.